Number 112, the people of the state of New York versus Roberto Estremera.
Good afternoon, Your Honors. Sam Mendez with the Office of the Appellate Defender for Roberto Estremera. I'd like to reserve 2 minutes for rebuttal, if I may.
You may, sir.
Thank you. Your Honors, if ever there was a clear rule, it is the rule that this court laid down in People v. Sparber. Sparber held that a defendant's right to be present and to be heard at the imposition of sentence is unyielding.
Does this boil down to whether this is a resentencing or not? Is that really?
That is one of the two critical questions in this case. And
so is Boyer relevant to that?
Excuse me?
Is Boyer relevant to that?
The case
familiar
Boyer?
With Boyer?
It has not been mentioned in the briefs so far, I'm afraid.
Okay, well, Boyer was fairly recent, and we said that a procedure under 7085 was merely to correct a clerical error and left the original sentence undisturbed. And that had to do with whether it could be used for predicate sentencing and time limits and things like that. So if the original sentence was never vacated and it remained valid, how could such a proceeding be deemed a resentencing?
Well, Your Honor, I would disagree with that notion that this was not a resentencing, because that does seem to me to be out of line with many of this court's cases, including the governor's approval memorandum for the statute itself, which characterized these proceedings as resentencings. The statute calls for the reimposition of the originally imposed sentence, which is to say that what had happened before must happen again.
And then the original sentence shall be deemed lawful.
Yes.
So, I mean, I guess this seems to me a little bit different from other cases, because there is nothing that the court can do other than restate a sentence that was previously stated in the presence of the defendant. So,
yes, Your Honor, but there are two problems with that argument.
That does seem to be the people's strongest point, though. So I guess I wonder if appealability is the key on this sentencing question. If a sentence in this case, which is a resentencing, can be appealed, then it would seem that 3080-40 would apply. But we are reimposing that sentence cannot be appealed. That's the way I read 7085. And I think, though, that is the strongest point, and if you can, I would address it in the oral argument.
The notion that the underlying sentence cannot be changed?
Right. The point is that when you're being sentenced, you ought to be able to speak, and it's not whether or not it's a futile exercise or not, or whether or not your speaking itself is an arrogant exercise. It's a fundamental right that's been statutorily imposed. So the question between whether something's being reimposed and you've already had that opportunity, or resentenced, seems to lie in the area of making a decision about whether or not that new determination can be appealed. The way I understand 7085 is it cannot be appealed afterwards. You're done. You've had your shot. But this sentence can be reappealed, and that's why you're here, obviously. And so that would tend to answer the problem that you have with, I think, the people's strongest argument.
Well, yes, Your Honor. This was as I read the statute, a full resentencing, again, because the statute specifically calls.
In some ways, it seems like we're talking about the bureaucratic inconvenience of bringing someone in 2 times to say something, and it's legitimate, it's real, it does impose a cost. There's no question about that. But and quite often, most statements by defendants may be futile, but that doesn't deny them the right.
That's correct, Your Honor. I would ask the court to look to the example that it's set in People v. Sparber. One of those cases, Thomas, which was decided with Sparber, in that case, the defendant, Mr. Thomas, was told before he entered his plea that he would have to serve a mandatory fixed 5-year term of PRS. There was nothing that the defendant could do to change that. Nevertheless, this court remanded Mr. Thomas's case and ordered that he, along with thousands of other defendants, speaking of administrative cost, ordered that thousands of defendants be resentenced
But in
in
those
their presence.
cases, they had never stood before a court to pronounce that sentence. In this case, that has already happened.
Well, yes, Your Honor, that is Respondent's argument. The problem with that argument, however, is that Mr. Estremera's sentence of 25 years in prison has never actually never been properly imposed. In 2001, Mr. Estremera's determinate term without PRS was an illegal sentence, and therefore, under 7085, it had to be reimposed. Mr. Estremera had to be resentenced, such that then, as Your Honor noted, the sentence would then be deemed a lawful
Just
sentence.
to clarify, perhaps in response to some of the questions you've already heard, so even if, based on the statute and our prior case law, the defendant doesn't have a merits ground to complain about the actual sentence, his complaint is about the procedure, right? Well, like other appeals where a defendant may complain that procedure has been violated and they're subject to some kind of relief for that violation, right?
Yes.
Isn't all he's seeking here?
That's correct, Your Honor.
Is to be brought in and resentenced?
That's correct. Mr. Estremera is asking for the very limited remedy that this court provided for in Sparber. And I think that the point of that case, Sparber, Garner, and these other cases, is that we are talking about a substantive right here.
Doesn't the court have another option besides imposing the original sentence, which is to say, I'm not going to impose the original sentence, and if that happens, then the plea is vacated?
That's correct, Your Honor. That remedy is one of the two options that were available in this case. Mr. Estremera
Where the
himself.
prosecutor is consenting,
That's correct, Your Honor. It was,
what is the purpose of the defendant being presented at the court, produced in the court?
well, in the first place, there's nothing in the statutory law or in this court's decisions, particularly Sparber, that suggests the right to presence is limited in this circumstance. And the point of
What would
this-
he have to add to the proceeding, sir?
Mr. Estremera has the right to make a statement on his own behalf. The point is that this.
Does he have to
What's
add
the-
anything? Or can a
We don't know
defendant
that
attend a
because-
sentencing and stand mute?
A defendant certainly has that right, yes, but the point of this right is that it does protect not just the defendant's dignity, interest, but also the dignity of the proceedings themselves. Mr. Estremera was absent from his resentencing to 25 years in
Do
prison.
those sentencing or resentencing minutes then get forwarded to any agency that either supervises his PRS? So like in an indeterminate sentence, those minutes would be used by the parole board. But what about here with a determinate sentence?
Your Honor, yes, because defendants also, inmates also, PRS is very, very much like parole, and defendants also seek to earn their conditional release. And this is one of those rare
Isn't
opportunities.
this, the whole point of this is he's not getting post-release supervision?
Oh, yes, Your Honor, but there's also such a, excuse me, that's correct. There is such a thing as conditional release, and Mr. Estremera will be seeking conditional release. And I see my time is up. The point I was trying to make with respect to the dignity of the proceedings is that this is a circumstance where the defendant, his presence has a symbolic purpose that I think is overlooked in respondents' briefs, and this court has never tied a defendant's right to be present to his or her potential contribution to the proceedings. If that were the case, defendants, as this court is aware, most cases, and in guilty pleas, and very often the defendant's sentence is set in stone before the sentencing proceeding. Nevertheless, the defendant does have to be present and to make a statement on his or her own behalf.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, good afternoon. Vincent Revelisi for the Manhattan District Attorney's Office. I think the key here is that this is not a full resentencing proceeding. This is just a proceeding where something that happened in the past is being made deemed legal.
Yes, but
because-
every single case has called it a resentence, including Boyer, may I say. And in every single case, we've said it's an unlawful, that original sentence without the PRS is an unlawful sentence. It's illegal.
That's correct. I think that the difference
Boyer
here,
dealt with sequentiality, not with the essence of the lawfulness of the sentence.
Right. And also, those cases weren't dealing with the right to be present because it wasn't presented as an issue in those cases.
Let me ask this. Why don't you want them to be brought in and let them make a statement?
I don't think that my office really has a horse in the race, and I'm just defending what the trial
Well,
judge
no, but
did,
I mean,
so-
just say, tell me, what would be the policy reason not to let someone make a statement at a sentencing?
Because if it's not a place where anything can be done based
All right.
on the statement.
I understand that policy. Okay, so let me follow that up then with another question. I had a plea to the minimum sentence. All I can get, I've got plea to an E-felony, and it's going to be determined, I'm getting 1 year and a third, and I can add nothing to the proceeding at all. Should I be allowed to speak? Because I'm not aggrieved, I can't get more than the minimum. And it seems that you're arguing for an aggrievement rule, and that's not what the statute says.
Well, I think in that situation, the judge still has discretion to impose a different
Well,
sentence.
this isn't
or
up to the
refuse-
judge. This isn't in the sense that the judge has discretion here. This is up to the defendant as to whether the defendant wants to speak.
Yes, well, and one difference here is that he already had the opportunity the first time that he was sentenced, and he was told and had the opportunity to speak about that sentence and got that sentence, which is the only thing that could have happened at this additional proceeding.
Doesn't he also have the right to observe this procedure? It may very well be that he observes what he considers to be an error in the procedure, to know what is being done, to hear the judge pronounce that sentence, and to then decide whether or not he wishes to challenge it?
If there were something that happened that aggrieved him, then he would have that right. I
See,
think,
that's the problem, I think, with your argument. That's the weakness that I focus on. I thought that people had a good argument on the reimposition versus sentencing. Judge Stein brought that. I think that's a strong argument. The problem I have with that argument is that that argument, in and of itself, assumes that there's no appeal. But where there's an appeal, you should certainly be allowed to speak. That's the distinction I see there. But this aggrievement article, this is a much more serious policy issue because we're not concerned when you don't get the right to speak at a sentencing because there's something to be gained. Usually, it's a cut and dry procedure, as you've been through hundreds of them probably. But nonetheless, we're talking about the face of justice, how it looks. And the fundamental right to speak at that moment seems to me a very profound right that shouldn't be diminished by the costs or the inconvenience of providing it, particularly when the statute says the defendant must be personally present at the time of sentencing is pronounced.
I think, again, it's just because of the peculiar circumstance of this statute. This is a statute that, I have to read it because it's a title that I wouldn't remember, the Transitional Exception to Determinate Sentencing Laws. It's not a statute saying how to resentence. It's not a statute saying resentencing. It's giving you some special information about a special circumstance. In this
See,
case,
there's not two rules in the statute for sentencing and sentencing. That's why your reimposition argument I thought was a good one, because it's an intelligent argument. But sentencing is sentencing is sentencing. There's not separate rules for these
What
things.
about the language in the statute that says when the case is before the court to determine whether to resentence?
because there could be a resentencing in that situation if, for example, the defendant did not receive the post-release supervision and no one consents to removing that from the sentence, he would have to be brought back and given post-release supervision or allowed to withdraw his plea. So the case could be before the court where we don't know yet whether the district attorney consents or whether the judge wishes to give the non-post-release supervision sentence, and then there could indeed be a requirement that there be a resentencing or a plea withdrawal. And of course...
I'm sorry.
Sorry.
Finish your thought, and I have a question.
Well, actually, I think it says that whether the case is again before the court pursuant to the corrections law, which required people to bring back defendants who hadn't received proper post-release supervision or otherwise. So it's encapsulating any situation where a defendant happens to be, or the case even, happens to be before the court, whether or not the defendant is.
So what do we make of the fact that the assistant district attorney who was opposing this 440, who's an experienced assistant district attorney, characterizes this in his opposition papers, or in his papers rather, basically taking no position about the resentence or consenting to the non-imposition of PRS, calls it a resentence.
Imprecision. Because at the time, nobody is talking about presence at a resentencing proceeding And it's imprecise
Because the
speech.
people really didn't care whether he was present or not. They had no objection to him being present. It was the judge who did this.
We wouldn't have an objection to him being present at all. It's not a question of objecting to it or finding that presence would be wrong. It's just that to say that he should be brought back down from prison to hear the same thing again, it's not required. That's our argument.
Would he be allowed to speak if he was present again for the purpose of generating a transcript of the resentencing that could be used, whether it's on conditional release or,
Oh, of course he'd be allowed to speak if he were there. I mean, we're not supporting a rule that he not.
And so if that's the case, why is that the case?
Because anytime a defendant is present in the courtroom, if he wishes to speak, it makes sense for the judge to hear what he has to say. But to say that he is required to be there to just hear that this post-release supervision is not going to have to be served when he already has been not serving it, it seems that's not the same as a resentencing proceeding.
So, counsel, I'm sorry to interrupt, but if we leave things the way they are, and I'm trying to understand the process of this, it's up to each individual judge whether or not they produce a defendant for this type of sentencing? It's not up to your office, right? You don't make the request.
Right. I mean, we would
So a
just.
judge in the next courtroom may say, yeah, I always want a defendant here for one of these proceedings, and the judge in this case may say, I never want a defendant here for this.
They could say that. They
Can you,
could say that.
can you help
How
me with?
common are
I'm sorry.
how common is this proceeding under 7085?
It was a little more common 10 years ago when it first happened. It's going to be less and less common over the years. This case is 20 years old almost. So it's not something that's going to affect thousands of cases. It's not something that's going to be a huge fiscal responsibility. And it's also not something that my office has a lot of interest in as far as we're not trying to exclude defendants. But as far as whether the resources of the state should be brought to bear to bring down a defendant, to hear that he doesn't have to do what he already isn't doing and was told he didn't have to do, it seems like that's not the same as a resentencing proceeding.
Can you help me understand Correction Law 601D subsection 4 if you have it there? If not, I'll read you.
I don't have it in front of me, but that's
So-
to bring the defendants back for the resentencing.
Yes, and this concerns what they call designated persons, who are the people like Mr. Estremera. 4 says, if the sentencing court shall not have issued a superseding commitment order reflecting an imposition of a term post-release supervision, then the court shall calendar such person for a court appearance, and then says, at such court appearance, the court shall furnish a copy of such notice and the proceeding date pursuant to paragraph C to the district attorney, the designated person, and assigned counsel. So when I read that, it seems to me that that contemplates the presence of the defendant in the court, receiving from the court in person that statement.
Yes, because if he were to be receiving post-release supervision at that point, that would be something he has not yet received. So he would have to be present to receive that. That would be an enhancement of his sentence. But if the district attorney waives the post-release supervision, there's nothing going to be added, there's not going to be any enhancement, so it changes the nature of the proceeding. That's why it's for consideration of whether to resentence as opposed to just for resentencing, because the statute doesn't contemplate that everyone that comes before will actually be resentenced. The judge is just considering whether they will be. And in this case, he wasn't. Unless there are any other questions. I'll
Thank you,
rest on the
counsel.
brief. Thank you.
Mr. Mendez?
Thank you. I'll be brief, Your Honors. This was a resentencing. Everything in this statute, 7085, and in the accompanying statute, 401D, indicates that this is meant to be a resentencing. As I noted, the governor's approval memorandum stated that very
When an
clearly.
appellate court reduces a sentence on appeal, is that a resentencing?
I think that is different, Your Honor.
Why?
Well, for a few reasons. In the first place, I don't think that the appellate division could modify a defendant's sentence in this way, because as I read the statute.
Well, no,
Yes.
in any case.
It is different, Your Honor, because the appellate division does have that extraordinary jurisdiction to do so, and it takes place in an appellate court where many, certainly of our clients, simply.
But if we're saying that no matter what the consequences, no matter whether the defendant has anything to add, no matter whether the defendant is suffering, is being aggrieved by it, whenever there's anything to do with sentence, that defendant must have the right to be present and be heard, then how is that different from this situation?
Your Honor, it is not our position that whenever anything happens with respect to a sentence, the defendant must be present. It is our position, and the law is quite clear, that when there is a sentencing, the defendant must be present. And sentencing, under the statutes, takes place in the trial court.
What happens if a defendant is sentenced 3 to 6 and the court determines, you know what, on appeal, he wasn't really a second felony offender, the sentence should be something less than that, does he have to be present when it goes back?
No, Your Honor. I don't think that, we're certainly not asking the court to find that. Our case is built around 38040, which is a statute that governs the actions of the trial court and the imposition of sentence. And it states very clearly, having nothing to do with appellate division proceedings, that in the trial court, the defendant must be personally present
But
at
if
the
it's
time
remitted by the
sentencing
appellate division, because, after all, there could be a range of sentences that could be imposed once it's determined that he's not a second felony offender.
To the extent that there is a resentencing or another sentencing proceeding, yes, the defendant must be present for that. I see my time is up, Your Honors. This is the very last in a long line of cases in which this court has dealt with the PRS statute and the quite unexpected crisis that occurred when that statute was enacted in 1998. This court has consistently stood up for the defendant's rights, including the right to be present at sentencing. And this case, which is very much of a dying breed, is not the case in which this court should alter that precedent. It should simply reapply Sparber.
Thank you, Mr. Mendez.